Good morning, everyone. Welcome to part 13 of this lecture series on the rules on criminal procedure. This morning, we are going to discuss about the trial. Okay, so let me share my screen with you. Rule 119, trial. Okay, now let us define trial. Trial is the examination before a competent tribunal according to the laws of the land of facts put in issue in a case for the purpose of determining such issue. So when you say trial, in short, this is examination. This is determination of the truth in order to resolve the issue in a particular case. Now, after a plea of not guilty is entered, the accused shall have at least 15 days to prepare for a trial, and the trial shall commence within 30 days from receipt of the pretrial order. Now, hearing is not confined to trial. Now, hearing involves several stages of litigation, including the pre-trial stage. So if you will compare trial to hearing, hearing is more broad in scope. Now, hearing can pertain to trial and also the pre-trial stage. Now, let us know the procedure of trial. The trial, once commenced, shall continue from day to day as far as practicable until terminated. However, it may be postponed for a reasonable period of time for good cause. Now, we have the Supreme Court Circular number 1-89, which requires the judges to conduct trial with utmost dispatch, meaning the several delays now without justifiable cause is not allowed because we follow the continuous trial system in our trial courts. Now, what is the order of trial in criminal cases? In criminal cases, the prosecution shall present evidence to prove the charge, and in proper cases, the civil liability. So under normal circumstances, the prosecution presents evidence first, and then the accused thereafter. Now, the accused may present evidence to prove his defense and damages, if any, arising from the issuance of a provisional remedy in the case. Now, this is only the general rule. Now, we have discussed during last meeting of a modified or reverse trial in case that the accused will hypothetically, not hypothetically, the accused will admit the allegations in the information but interposes a defense. Then, for example, in a case of self-defense, defense of a relative, or defense of a stranger, not in under Article 11 of the Revised Penal Code, or the justifying circumstances, then there will be a reverse trial. The accused then will now present evidence ahead of the prosecution because, again, the allegations of the prosecution have been admitted by the accused. Okay? Now, after the prosecution and the defense presented their evidence, then they can present a rebuttal and rebuttal evidence unless the court, in furtherance of justice, permits them to present additional evidence bearing upon the main issue. So after the presentation of the prosecution and the defense, there will be a rebuttal and rebuttal evidence, but this is only optional on the part of the parties. They may also not avail of this procedure, meaning after the prosecution and the defense, then the case is deemed submitted for judgment. But if the parties will deem fit, then they can opt to present rebuttal or rebuttal evidence. What is a rebuttal or rebuttal evidence? These are evidence which will controvert the evidence presented by the prosecution and the defense at the first instance. Okay? Now, upon admission of, so once the prosecution is done with its presentation of evidence, the prosecution will formally offer the evidence. Now, formally offer. So that is what we call as formal offer of evidence. Likewise, the accused, no formal offer of evidence, because no evidence may be admitted in court unless it is formally offered. Now, after the formal offer of evidence, for example, the prosecution filed its formal offer of evidence, or under the new rules, there will be an oral offer of evidence. Then the opposing party or the accused will be given the opportunity to submit his comment or objection on the admissibility of the evidence. Now, the court will rule thereafter whether the evidence is to be admitted, and once the evidence is admitted, the case is submitted for judgment. Okay, unless the court directs them to argue orally or to submit written memoranda. Okay. Now, if the judge is not satisfied with evidence adduced in criminal cases, he may, on his motion, call a witnesses or recall some of the same witnesses for the purpose of satisfying his mind with the reference to particular facts involved in the case. Okay. Okay. So upon admission of the evidence in chief, rebuttal, and rebuttal proof, as the case may be, the case is submitted for decision or judgment. Now, what are the instances where presence of the accused is required by law? Remember this class, you have to memorize. These are the exclusive list, or this is the exclusive list of instances in criminal cases where the presence of the accused is required, meaning the accused is required to personally appear in court. 1, upon arraignment. 2, during trial when his presence is necessary for the purpose of identification. 4th, upon promulgation of judgment except for light offenses. And 4th, when the court with due notice requires so. Okay. Now, the trial shall not exceed 180 days from the first day of trial, except those cases governed by the rules on summary procedure. Those where the penalty prescribed by law does not exceed 6 months of imprisonment or a fine of 1,000 pesos or both, or those authorized by the Chief Justice of the Supreme Court pursuant to the Speedy Trial Act to exceed to 180 days. Now, if the judge does not comply with the period of time within which the case is to be terminated, then he can be charged administratively or may be fined, suspended, or removed unless with justifiable reason. Okay? Now, there are cases where the time limitation does not apply. Number 1, when the offended party is about to depart with no definite date of return in child abuse cases, in violation of dangerous drugs law, kidnapping, robbery by a band, robbery against banking or financial institutions, and violation of Kidnapping Act and other heinous crimes. So do not apply the 180-day trial period in these cases. Now, please memorize the enumeration. So what are the duties of a presiding judge under the continuous trial system? The judge will have to adhere faithfully to the session hours prescribed by law. He shall maintain full control of the proceedings, allocate and use the time and court resources to avoid court delays, and continuous trial on a weekly or on a short-term trial calendar at the earliest possible time. Now, there are exclusions in computation of time within which the trial must commence. In other words, these are factors which are not considered when computing the time of trial. So, any periods of delay resulting from other proceedings concerning the accused, including but not limited to the following: examination of physical and mental condition of the accused, proceedings with respect to the other criminal charges against the accused, extraordinary remedy against interlocutory orders, pretrial proceedings, orders of inhibition, finding the existence of prejudicial question, and reasonably attributable to any period not exceeding 30 days. Okay? Any period of delay resulting from the absence or unavailability of an essential witness. So you do not include this in the computation of the trial period, no? For purposes of determination of whether there is compliance with the Speedy Trial Act. Now, any period of delay resulting from the mental incompetence or physical inability of the accused to stand trial And if the information is dismissed upon motion of the prosecution and thereafter a charge is filed against the accused for the same offense. Any period of delay from the time the date charge was dismissed to the date that the time limitation would commence to run as to the subsequent charge had there been no previous charge. Okay. Okay. A reasonable period of delay when the accused is joined for trial with a co-accused. Okay. Okay, so these are the factors to be considered for granting continuance. When you say continuance class, this means postponement. So whether or not there is failure to grant continuance, as would make a continuation of the proceeding impossible or result in miscarriage of justice, or the case as a whole is novel, unusual, and complex. So these are the prohibited grounds for continuance or postponement of hearing: congestion of the court's calendar, or due to lack of diligent preparation, failure to obtain available witnesses on the part of the prosecutor. Now, this is the time limit following an order for new trial. So, if the accused is to be tried again pursuant to an order for a new trial, the trial shall commence within 30 days from notice of the order, except if there is, if the 30-day period becomes impractical. No? Okay. So what are the duties of the public attorney or the defense counsel when the accused is imprisoned? He shall promptly undertake to obtain the presence of the prisoner for trial, and upon receipt of that notice, the custodian of that prisoner shall promptly advise the prisoner of the charge and his right to demand trial. Okay? Okay. Okay. Now, let us go to the conduct of trial for for several accused. Now, it happens sometimes that there are many accused, no, in one case. So what is the rule? When there are two or more persons who are jointly charged with an offense, they shall be tried jointly. So there will be a joint trial. Now, meaning these several accused will face only one trial proceedings, except when the court, upon motion of the prosecutor, or any may order a separate trial, any one or more of the defendants or the accused. Okay. Okay, what do we mean by the term trial in absentia? Now, trial in absentia under the Constitution provides the trial may proceed notwithstanding the absence of the accused, provided that he has been duly notified and his failure to appear is unjustifiable. So, if the accused was notified of the date of the hearing and he fails to appear, then the court will proceed notwithstanding his absence. So that's what we call as trial in absentia. So class, please memorize the requisites of trial in absentia. When you say in absentia, the accused is personally not present. So the accused has been arraigned. This is the most important requisite of trial in absentia. There can be no trial in absentia if the accused had not been arraigned. Number two, he has been notified of the trial. And third, his failure to appear is unjustifiable. So what are the effects of trial in absentia if the accused unjustifiably refused to appear in court hearings after arraignment? Then that failure to appear or refusal to appear will have the effect of waiving the right to present evidence and to conduct cross-examination against the witnesses presented against him. No? Okay. 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 Now, if the right of the accused to a speedy trial is violated, what are the available remedies? Number one, he can ask for the trial of the case. Number two, unreasonable delay of the trial in criminal cases so as to make the detention of the accused illegal gives ground for habeas corpus as a remedy for obtaining release. Number three, mandamus proceedings to compel the dismissal of the information, or 4, ask for the trial of the case and then move to dismiss. Okay. What are the requisites for discharge of the accused to become a state witness? Now, what is a state witness? A state witness or witnesses is one of 2 or more persons jointly charged with commission of a crime, but who is discharged with his consent as such accused so that he may be a witness for the state. So, class, sometimes the evidence of the prosecution is insufficient. No? There are some evidence which are lacking, and therefore it can result to a possible acquittal of the accused. Now, sometimes the prosecution, in order to fill out those gaps in the evidence, then he can ask one of the accused to testify for the prosecution. So he is an accused, but he will be taken by the prosecution as a witness. So class, akusado siya pero gagawin siyang testigo ng prosecution in order to strengthen its case. So that is what we call as a state witness. No? So what are the requisites before an accused may become a state witness? 1, there is absolute necessity for the testimony of the accused whose discharge is requested. 2, there are no other direct evidence available for the proper prosecution of the defense committed except the testimony of the said accused. 3rd, the testimony of the said accused can be substantially corroborated in its material points. So please memorize the requisites before an accused may be admitted as a state witness. Absolute necessity for the testimony. There is no other direct evidence available, and the testimony can be substantially corroborated in its material point. 4, said accused does not appear to be the most guilty. Now, a state witness may not be the most guilty of all the accused. If he is the most guilty, then he cannot be admitted as a state witness. And 5, said accused has not at any time been convicted of a crime or offense involving moral turpitude. So these are the requisites. Please memorize. Okay. Now, what is the period for the application for discharge of the state witness? It should be made upon motion of the prosecution before it rests its case. Okay. Now, what are the effects if an accused is discharged as a state witness? As a general rule, such act on the part of an accused will have the effect of acquittal. Now, if the accused is discharged as a state witness, then that discharge will amount to an acquittal. It will bar further prosecution for the same offense, and that evidence adduced in support of the discharge shall automatically form part of the trial. Okay? But if the court denies the motion to discharge the accused as state witness, his sworn statement shall not be admissible in evidence. Now, let us talk about demurrer to evidence. What is a demurrer to evidence? We have compared this concept to motion to quash. We said before that a motion to quash is in the nature of a motion to dismiss because the information filed in court is not valid. On the other hand, a demurrer to evidence is also in the nature of a motion to dismiss, except that the ground for demurrer to evidence is that the evidence presented by the prosecution is insufficient, or there is lacking. No, there is some elements of the crime which have not been proven by the evidence of the prosecution. So if there is insufficiency of evidence, the remedy of the accused is to file for demurrer to evidence. It is an objection on the part of the accused to the effect that the evidence presented by the prosecution is insufficient in point of law, whether true or not, to make out a case or sustain the issue. Okay. Now, A demurrer to evidence can be done by the court on its own initiative or upon the accused upon filing of a motion for leave of court to file demurrer to evidence or motion to demurrer or motion for demurrer of evidence. No, these can be filed with leave of court or without leave of court. No. Now, when do you file a demurrer to evidence? It is filed after the prosecution has rested its case. No, after the termination of the presentation of evidence by the prosecution. Again, the ground is insufficiency of evidence. Now, if the court will rely or will sustain a demurrer to evidence, it will have to dismiss the case. Now, what are the distinctions of a motion to demurrer to evidence or demurrer to evidence with or without leave of court? Sabi natin kanina, a demurrer to evidence can be filed with leave of court or sometimes without leave of court. Ano bang tinatawag na leave of court, class? When you say leave of court, this means permission of the court. So sometimes the defense will file a motion for leave of court to file demurrer to evidence. That means that the accused is asking the court to file, if he can file a demurrer to evidence. Now, on the other hand, if the demurrer to evidence is said to be filed without leave of court, that means that the accused is filing demurrer to evidence directly without permission from the court. Now, if demurrer is filed with leave of court, if leave of court is denied, the accused may proceed with presenting his evidence. Now, so for example, the accused filed the motion for leave of court to file demurrer to evidence, and that motion is denied, then the accused will present evidence. On the other hand, class, remember that if demurrer to evidence is filed without leave of court, and that motion is denied, then it will amount to a waiver of the accused to present evidence. The right of the accused to present evidence will be considered as waived, and therefore, the case will now be submitted for judgment on the basis only of the evidence for the prosecution. Now, demurrer to evidence with leave of court, the motion for leave of court to file demurrer to evidence shall specifically state its ground and shall be filed within a non-extendable period of 5 days after the prosecution rests its case. The prosecution may oppose the motion within a non-extendable period of 5 days from receipt. Now, demurrer to evidence without leave of court, if a demurrer to evidence is consequentially granted, then the case will be dismissed and will result to an acquittal of the accused. So, class, if demurrer to evidence is granted, then the accused is acquitted and the case is dismissed. Okay. Remember the distinctions between demurrer to evidence without leave of court and demurrer to evidence with leave of court. Actually, class, under the continuous trial, after the prosecution has rested its case, the accused shall orally move for demurrer to evidence or motion for leave of court to file demurrer to evidence. No, wala na yung mga filing ng written pleading or written motion. No, after termination of the presentation of evidence of the prosecution, the accused can move orally or verbally for demurrer of evidence. Okay. So what is the purpose? Why does the accused need to file motion for leave of court to file demurrer to evidence? No? This is to determine whether or not the defendant in a criminal case has been filed a demurrer merely to stall the proceedings. Okay. Now, what are the distinctions between a demurrer to evidence and a motion to dismiss? Demurrer to evidence assumes that the prosecution has already rested its case. No? On the other hand, in a motion to dismiss, it is based on the denial of the accused's right to the speedy trial, characterized by unreasonable, vexatious, and oppressive delay. The merit evidence can be filed with or without leave of court, while a motion to dismiss is filed without leave of court and before the prosecution has rested its case. So this ends our presentation for trial. I'll see you again next meeting. Thank you.